is Martin Holdsworth. I am the founder and CEO of a law firm called IDR Law. IDR simply stands for Inheritance Dispute Resolution, which probably gives you a clue as to what it does. In fact, IDR Law itself is a law firm that specializes purely in contentious probate, which is very similar to my background, because I've been doing contentious probate since, well, before it had a name. So I was a trainee in 1993 when I did it, giving away my age, but I was round about there when I did my first, what I didn't realize at the time was a probate dispute, because I had a number of farming children arguing over a farm that hadn't been gifted equally between those that survived. So a familiar tale. So what I want to try and hopefully achieve from the webinar today is a straightforward explanation. First of all, an introduction to who we are. I think that might well help. Then to provide you with some background about the sector itself. You will have read, well, you couldn't have missed if you read any of the newspapers, particularly Daily Mail, that there is an increase in contentious probate disputes. The number of cases issued in the High Court in London are going up year on year. They seem to report that there are more being done. I'll tap into why I think that's the case and what will feed through to you and what you will see with your clients. And at the end of it, we'll provide you with some ideas as to how we can help you, how we can provide you with support and also potentially some new income streams and protection. So it's a fairly wide-ranging webinar. It's fixed for an hour. Lunchtime is the target. So I don't want anybody not eating sandwiches now. You will have time. We will finish by 1 o'clock. I'll aim to do that. There's a chat. I've got the chat open. So if anybody has any questions as we go through things, please do ask. Just put it in there, drop it in there, and I will respond to it as soon as I can, as soon as I spot it as we're going through at the right time. There are no wrong questions. It's just questions. So if things that you've experienced or things you're not sure about or need to clarify, please do drop it in there. At the end of this, we will follow it up with a copy of the slides, so you don't need to worry about keeping those, and also a number of links to various things that I'm going to mention from time to time as I'm talking. This is being recorded. So if you want a copy of the recorded webinar itself, if you can't sleep on a night, you need to hear my voice, then I will be happily provide you with that, and you can listen to it all over again at that stage. So with the housekeeping duly done, what I'm going to do is share my screen as best I can. So I'm going to share it with some slides. So I'm hoping you can see in front. Please do let me know if you cannot see my header page that's on that. So what you'll see there is I'm talking about accountants dealing with wills and probate. Congratulations to all of you who have taken the plunge and the step to get the necessary regulatory approval and consents to be able to offer this area of work. We are a law firm that deals purely in contentious probate. So we don't do any of the non-contentious elements, which is in fact the only firm that's doing it that way around. So what that enables us to do is to help with you and your client without stepping on your toes in terms of what you're doing, but then provide you with the support as and when you need it. So in terms of where we are and who we are, there is a pleasant infographic I'm hoping you can see. If you're listening to this on your phone, it might be a little bit small, but I'll go through it. Top left, there's a number of boxes all joined up with lines. IDR Law was formed in 2017, so we've been running for 7 years now. I've been dealing with disputes for a lot longer than that, as you will have gathered. I sit on ACTAPS committees and various other things that you would imagine in this particular area once you specialise. The firm itself, in those 7 years, we've dealt with 7,000 clients' inquiries. So I'll give you some idea of size. That slide was done a few months ago, so that's probably a little bit light now. We'll have gone up from there. We are predominantly a B2B type practice, so we get most of our clients, a good 90% of our clients come directly from other businesses who come across situations that need our help, and currently have over 250 different referral sources of work. So one thing you have to remember about contentious probate is that it is a little bit like a crime watch warning, if you're old enough to remember such things, is 5%, maybe rising to 10% of all estate administrations will need our help. But of course, that means that 90 to 95% of your estate administrations will proceed without the need for us to get engaged and involved to help you sort it. So one of the problems that we had originally was making sure that everybody knew who we are and where we are when they needed us. And the way we've addressed that is that we've created a free support network called the IDRN network. We'll give you a link. It's free to join. And in there, it's got all kinds of resources, information, and also links to some legal tech and other things that we think you might find quite interesting. So insofar as where we are in size, legal team is now 20 strong, and that's 20 lawyers. That's not, we've got support staff that number about 6. So when we started in 2017, there was me. I built teams before in big firms and medium-sized law firms, but we started on my own, and then we built 2, then 3, then 4, and so on. And 7 years further on, we are now 20 lawyers strong. We've got 18 showing on our website, with 2 more that are arriving very soon. We also have a triage team of 3. So we have 3 full-time people dealing with nothing but incoming inquiries to make sure that they are empathetically found in the middle of all that, and then they refer that on to the legal team to assist. We've got 7 ACTAPS members. I think that's actually now 9. And I was a former committee member. ACTAPS, as you're probably aware, is the STEP equivalent, if you like, of for contentious probate lawyers. We've got all the usual badges in respect of, I'm so old, I'm now the Hall of Fame Legal 500. I'm not sure what that means, but anyway, I'm Band 1, Chambers and Partners, and the firm is likewise. Based home for me is Harrogate. I'm sat in my office at home, but I'm living Wetherby between Harrogate and Leeds. But we've got offices in Harrogate. I've said Bristol there, but it's actually Manchester. I don't know why that typo there. So it's Manchester. And as I say, we're the only law firm dealing with contentious probate and nothing else. We've got NPS scores, Net Promoter Scores of 88 and 90. 88 is facing into our clients, and 90 is facing into our referrers. So those are, as you're probably aware, the average for law firms in terms of client care and feedback is an embarrassing 35. So 88 represents a hugely impressive return. We are PE backed, so some of the growth that we've achieved came on the back last year of a minority PE investment from the British Growth Fund, and they provided us with a fund and some liquidity to be able to carry on growing like we are. So the plan currently is for the next 2 years, we will be 3 times bigger than we are in terms of turnover, EBITDA, and the rest that you accounts will know all about. So hopefully that gives you some idea of size. There aren't many firms. In fact, there's only one firm I could think of nationally who's got a bigger team. But the important thing is we only deal with contentious probate, and that's the bit that sets us apart from our competitors. So why so many claims? I've started with the statement, there are more claims happening. What I thought I would do as a starter is share with you why I think that's the case. You know, some of those factors you will come across, and just to pad those out a little bit, is my view is that these 6, you can see the 6 boxes, and then the infographic sort of icon 1 in 3, which I'll talk about last. But bottom line is still, you know, I've been in this sector 25 years, and 60% of people still die with no will. And as you and I both know, dying intestate is not the best way to die. Very rarely does it actually result in a fair distribution, or one that's appropriate. It's certainly very rarely tax efficient to provide for a family. And as a result of that, something needs to be done to resolve it. Now, friendly families might be able to do that through a deed of variation of some type, all kinds of things that can be done. So, but the bottom line is this, is that 2/3 of people dying without a will means they've not even had a conversation in life about what should happen on death. And that is probably the most important bit, I would suggest, of the problem that flows through to us at our end. The great wealth transfer you will have heard all about, I am sure, and from my point of view, we're seeing evidence of it for sure, is baby boomers, 1.3 trillion passing in the next 5 years. Those numbers seem to fluctuate depending on which survey and report that you read. What I do know is this, is that the expectation that's now crept into inheritance has gone way beyond just an anticipated amount. It's actually, if you look to the right, 1 in 3, there was a survey carried out by a large insurance company who found that 1 in 3 people were now relying on an inheritance to either fund debt or fund retirement. And that's 1 in 3. It's not an expectation or a hope. It's now become a reliance upon it. And I was reading the week, and there's a book coming out this month, actually, something called the inheritocracy, which is the notion that the amount of money that's passing down through the baby boomers down to Gen X and below is such a wide cross section that society is now beginning to divide on a new line, which is those that do inherit and those that don't. And you can probably see that in your peers and people around you, is that certainly when I speak to my own children who are sort of post-university nowadays, is that some of their friends are already on the property ladder, and you ask how, and it's because they've inherited money and they can't get it. And as a result, there is a divide then between those that can and those that can't. And there's a great book coming out this month, apparently, that deals with this particular subject. So I'll put the link in that when we send that through at the end of today. People living longer, dementia rates rising. Second limb of that is fairly obvious in terms of claims, is dementia rates going up. There's a problem with that inherently, is that if you're making a will, then you are required to have testamentary capacity to do so. So if the dementia rates are rising, then it stands to reason that actually it's going to be more and more people who are going to be of questionable mental testamentary capacity, and therefore challenges come around. And the fact that people are living longer is probably, in my view, linked directly to the fact that dementia rates are rising. As our minds grow older, they are more prone to suffering from dementia, just as a statistical analysis, I would suggest. So those two things do cause a problem. And the other thing we see a lot of is because people are living longer, it gives them the opportunity to change wills, very often late in life. Sort of they're changing 2 or 3 or 4, and sometimes we have 7 or 8 wills as grandparents fall out with their children, or you're in, you're out. We've all watched Succession on TV. It's not quite as dramatic and as many helicopters, but it's the same kind of notion, isn't it? That people use this to be able to try and control both before and after the grave. Blended families is American phrase, but it refers to the fact that you've got more and more families who are coming together on second divorce and marriage. So you've got 2 lots of children from separate sides coming together, 1 new family unit, but of course the 2 sides came from different sources. That in itself is not a problem. 2 out of 3, I understand, are now blended families. Many get on. The problem with blended families for us is that if there are any fracture lines that exist within that blended family, then our experience is they tend to deepen and widen on the death of the first person in that couple. And if they are deep enough and wide enough, what you'll get is this notion of sideways inheritance or disinheritance, of the surviving partner then preferring their own blood children rather than their stepchildren in respect of a joint estate. So you could have stepchildren suddenly not only losing their parent, but actually also losing their inheritance. And if they're the 1 in 3 relying on it, you can imagine claims will then flow. Blended families are not surprised, really. If you think about it, the late 60s, early 70s was the time period at which people started to divorce and get remarried. So at that time, sort of Lord Denning was a great champion, wasn't he? In 1973 was a Matrimonial Causes Act that helped women following divorce. Then the 1975 Act came out, the inheritance one, that allows somebody to apply to court to vary the terms of a will to make reasonable financial provision. But these are 1970s, this is after my birth of 1970. So it's astonishing that it took so long to come into place. But of course, that then allowed people the freedom financially of being brave enough to split, remarry. And of course, those people are now dying. So no surprise that 50 years on, second marriages do start to get more and more in terms of proportionate size to the group of people dying generally. Litigious Society, raising awareness, New Frontiers. This is just happening. The number of people advertising no win, no claims. I'm sure a lot of you have heard about the Islet and Mitson case many years ago, where an adult beneficiary child brought a claim and was successful for the first time. Our phones all started ringing as adult children started to bring claims, and then the Court of Appeal decided to knock one side of the dispute out and then bump it up again. The phones rang again. And then 10 years after the first trial, the final trial took place at what is now the Supreme Court, and they put it all the way back down to the lower level of awards. So for a £50,000 gift in an award, there was apparently £1 million worth of legal costs incurred over a 10-year period, arguing about what basically is a discretion for the judge to decide how much they should or shouldn't give. So again, it gives you some idea of why people are now so keen. You'll have people like the Daily Mail, again, I keep Daily Mail bashing, but they're the ones that publish the most, talking about what's the point in making a will. I'm sure you've heard that before, because if you can drive coach and horses through, or anybody can make a claim, then what's the point? You and I both know that that is half the argument. The other half is you are always going to be better off having a will in place than intestacy. So it is a no-brainer to get that organised. And then DIY COVID wills, online wills as well, I'd say as well, because what we do know is that there is, on a survey we carried out, we think there's on average an 8-year period between somebody executing a will and a claim being started. Again, that's from a survey we carried out in the sector, and that was our own. And what was clear is that these claims were coming and increasing in number, and it'd be interesting to see with online wills, because they started about 8 years ago. So I think they are going to be the subject matter of claims as people get more desperate. I'm not saying online wills are wrong or bad. I'm just simply saying it's a new kind of media, if you like, for producing wills that are then going to be challenged. COVID wills, as we know, signature clauses, those kind of things, 8 years. You've got a little bit of time before we start seeing those wills coming through and disputed. But hopefully that gives you a flavour as to why none of that stuff is going away, is it? That means that you are going to see, we are going to see, and probably gives you an insight as to why private equity could see that actually investing in a firm that just deals with this kind of dispute and can tap into all the B2B market without spooking anybody about their clients is why we're doing what we do. We do work both in life and in death, but I'll come on to that in a minute. But ostensibly, hopefully that gives you some idea of what you already knew, but put some details to it. So far as claim types are concerned, and again, I'm not going to get too techie on all of this. I'm happy to run sessions and training and all that kind of stuff. That's all appears in our IDR network. So you can see webinars on pretty much any part or subject matter of anything I'm talking about today, to be honest, or I'm happy to come along to your own offices to provide you with some training, or we have something called the Bring Out Your Dead meetings or avoid meetings, where we book in, come to you, and then you just grab the pile of files that's been causing you the most grief and not sure what to do with, and we sit down and we go through them. And experience tells me every time I've done that, for every 10 files that we talk about, 3 of them will need my help straight away, or our help straight away. 3 will be a watching brief of, well, if this happens, then do this. If that happens, give us a call. And then the remaining sort of 4 files, I'll simply be saying, that's fine. You know, what you've done is absolutely fine. You don't need to worry about it. You can put those files away or carry on acting as you are. So those kind of things are, again, are all open to you. But so far as if I was summarizing, as I am, the different claim types, then they are, there's 4 there that I've given you. One is administration disputes. These are your nightmare, aren't they? These are the ones where you might be a co-executor with somebody, or you are the sole professional executor or administrator of the estate, and you've got disputes about how you should do it, valuing assets, how you should apportion estates between a number of beneficiaries. They may be unhappy about the way in which you value any property, any asset. What about contents? You know, how do we divide contents between and chattels between the beneficiaries? Those kind of disputes. Just on the contents point, we've identified that as one area actually, which is hugely expensive for very little financial benefit. So what we've done is we've created something called an iDivide app, which the iDivide sort of sits on our IDRN. And what it does is it provides, by way of a perceived fairness algorithm, a a solution to that particular problem. So beneficiaries, you list the items to be divided. The beneficiaries then are taken through a bidding process, and then the maths algorithm is applied, and a professor drafted the whole, it's beyond, even though I've got a maths A level, it's beyond me, is that this particular algorithm produces results which astonishingly everybody declared them as fair when we did all our test runs. So the thing works, and that probably gives you an idea of where we're at. Is that my background is maths, physics, computer science. So as a firm, we're very techie, interested in data. We track everything. We give lots of MI and BI back to those that refer, and again, PE interested because they got access to all of this and can see where we were going in the direction of travel. So admin disputes are probably the most annoying, irritating type of claim. Very often you end up solving that by literally removing the people that are causing the problem and dropping new people in who can resolve it. So, but we can do that. We can talk people through what your options are and how we can deal with it. The remaining 3 claims, probate claims are claims essentially where you are suggesting that the will itself is invalid, and you're arguing that it's invalid and therefore should be ignored, and that the estate should be distributed or dealt with as per an earlier will, or if there is no earlier will that's valid, under the rules of intestacy. Now, the probate claims I'll talk about in a second, various ways, grounds which you're doing it, but the important thing is they are looking to get that will knocked out. And if it does, if you are named as administrator or executor, you will go with it. So whoever's appointed in the prior will then have the right to take over. So again, it's definitely worthwhile keeping an eye on that. 1975 Act claims refers to the Inheritance Provision Family Dependents Act of 1975. And these are aimed, you'll have heard about these. These are essentially an argument that suggests, okay, I'm not trying to say the will is invalid, although sometimes these run side by side, but the 75 Act says the effect of the will, the terms of the will, or indeed the effect and terms of the intestacy rules, means that I am not receiving provision that I consider to be reasonable in the circumstances. And those kind of reasonable, this act came in 75, really new. The Wills Act came out in 1837. So you can imagine it's well over 100 years worth of testamentary freedom, giving what you want to who you want, and nobody could do anything about it. The 75 Act, however, does allow the court the discretion to step in and vary the terms of a will, or indeed the terms of an intestacy. Brilliant act, really good behind it, the theory behind it, and like most good things in life, totally spoiled by people on the fringes who are using it as an opportunity either to claw back what they were expecting but not entitled to, or even worse than that, they don't really have a claim, but they're causing as much trouble as they can with a view to trying to get some kind of nuisance payment out of it. So we do see a lot of 75 Act claims. There are a closed number of people who can bring the claims. So you've got spouses, cohabitees, you've got children, you've got financial dependents who've been receiving it for periods of time. Lots of rules, full seminar we can do on this, no problem at all. Lots of that information. In fact, there's a separate section on it in the IDRN. The 4th one is equity claims, and these are almost in order, to be honest. People tend to run with a probate claim. If not, I'll run with a 75 Act claim. If not, I'll run with an equity claim. And the equity claims in simple terms are an argument that a promise or some inequitous result has occurred because of some behaviour, invariably by the deceased or the testator. So what the common example of this one is, the one that I first started with in 1993, is where somebody promises, and then the person who receives the promises relies on that promise, and they do so to their own detriment, and then the promise is not fulfilled. And what the court will do is it will step in and say, we're going to allow that promise to be enforced. So using the farmer as an example, there's a case called Suggett that I was involved in, and John came to see us because he'd been promised the farm by his dad, and having been promised the farm by his dad, is one of 4 children. The farm was worth £3 million. The whole, well, 2.5 million. The entire estate was worth £1 million on top of that. And what the dad did, despite promising this to the son then carried out loads of work, became a qualified, had his first flock of sheep at age 7. You get it. He worked hard and assumed he was going to receive it. Lived in the farmhouse, had his own partner, 3 more kids of his own, But when his dad died, he was in his mid-20s, and the will that was read out provided for the entire estate to pass to one of his older daughters. It's one of the most extraordinary wills I've seen for a long time. And essentially, he'd done the will when John was 17, so he felt he couldn't gift it to John because he wasn't 18. So what he did instead, rather than just simply making another will a year later, is that he put a provision in there gifting the whole lot to the oldest sister, with the proviso that if you think John is a good farmer, then please pass him the farm. Well, you can imagine. We took the view that John was a good farmer. His older sister did not, and she denied him his inheritance. So we then had to make the claim to the court, and we were successful in recovering the farm out of the estate for John, where he still is, I suspect, with a bigger flock of sheep and more cattle. So equity claims are really the last bastion, difficult to prove because very often the best witness is dead. But nevertheless, there's no doubt there are more claims now coming around through equity. Probate claims, this is, I think, just to put things into context, and really this is what this talk is about for you, is just an overview, give you a flavour, give you some context, give you some indicators as to where I think we can help you. But hopefully, if there's any aspect of what I'm talking about that you take the view is, well, I'd like to know a bit more about that, then please do just get in touch with either myself or Lindsay, and we'll sort something out for you. As I say, my background, I do have a maths A level, so I'm kind of like my maths and my data. This is a Venn diagram for those people who are sort of looking back to their school days. Venn diagram, and I've done it in a way that demonstrates how these various allegations or grounds for rendering a will as being invalid overlap. 1975 Act claims I put outside of the group because, of course, that applies whether or not you've got a probate claim. The size of the circles or the ovals is gives you some idea of the volume of those cases that we have. So you'll see, for example, that mental capacity challenges are the biggest ground upon which wills are challenged. Lack of knowledge and approval, there's a massive overlap on that. If you lack mental capacity, the chances are that you couldn't understand, know, and approve the will either. So there is an overlap. Undue influence, much easier to unduly influence somebody who has sort of fading mental capacity. Fraudulent calumny is a fantastic phrase from all the old Victorian days, which is basically poisoning of the mind. So it's that drip, drip kind of so-and-so doesn't love you, so-and-so doesn't come round, so-and-so wants your money. That drip, drip, drip that then causes the deceased testator to have a wrong view of somebody and therefore miss them out of the will. Fraud and forgery tend to be the dramatic ones. I've had lots of those cases over the years. They're always dramatic. Invariably, you end up with two types. Either somebody sort of forges the signature of both the testator and the two witnesses, or somebody gets two accomplices and does it together. Much harder on the latter. Somebody always cracks, and we sort it out. The other two are interesting. Formality and irregularity is basically you just get it wrong with the will or the execution, or there's some terms in it that are too vague, or you're putting charity names for charities that don't exist. But if you're knocking out a will, a formality irregularity would have to be something quite significant. If you breach Section 9 of the Wills Act, for example, and you didn't get the will signed and witnessed in the correct way, courts are very reluctant to find against wills unless they absolutely have to. And it's worth bearing that in mind, that lots of probate claims are intimated, argued, put forward, and even issued, but not so many of them get home on these things. Some do, but it's not as easy as you would imagine. Revocation is the one that lots of people get caught out by. You can revoke a will in a number of ways. The obvious one is in another will. So if your next will, you've got that fantastic clause at the beginning that simply says, I revoke all previous wills and testamentary dispositions. That is a revocation, provided that will stands. You've then got revocation as a matter of fact. You've got revocation of literally tearing it up and saying, I'm destroying my will, I'm revoking it. You need the same level of mental capacity to destroy a will as you do to make it, bear in mind. So that all needs to be recorded and checked if you're asked to do it. And you're also in a position where marriage evokes a will, the one that people miss more often than not. You'd be amazed how many claim letters we get coming in. They're arguing for something without them twigging that actually there's a marriage intervening that actually throws out the will in any event. So it happens more than you would think, I'm afraid. And then 1975 Act's probably the biggest single area of claims coming in, because there's nothing more to show to bring a claim other than you are a qualifying person to bring the claim. Bringing a claim and succeeding, two different things, but you will find people will bring them. So probably 50% of the claims that we deal with are 75 Act claims coming through. This is the bit I wanted to share with you, because you're particularly is you are drafting wills at I know you do administrations as well, but you are drafting wills at your end. And because you're drafting wills at your end, you, like it or not, you are going to get dragged into any dispute that raises itself in respect of those wills. Starts with, and I suspect, I don't know how many have you received already. I'd be surprised if you haven't, a Lark and Nugas letter. So this Lark and Nugas was a case reported essentially where the judge decided that the usual rules of confidentiality and privilege should be waived on a deceased estate if access to this information is required to assess and consider whether or not a probate dispute claim has got merit. So you will get these letters, and ours, for example, has thick end of 32, 33 different types of questions asking about how did you first meet the individual, what were they wearing, who did they come in with, how did they seem, what assessments did you take? You can imagine, if you've had one, you'll know. These things take a long time to respond to, and invariably in the back of your mind, you're always worrying that, have I done enough? Did I keep enough notes? Those type of things. We do have another bit of legal tech as an aside, something called Lark. If you look at LARKE online.co.uk, is a great way of providing yourself with a Lark response at the time you make a will. So the idea is that let's get this thing battened down, knowing what we know about the claims and the questions you're going to be asked. Let's answer them in life. So if there's any spaces, gaps, you can fill them at that time. You can recharge that out to your client as a protection document. And that works really well. But again, that's something we'll circulate. So because you're the one that actually is important, why is it so important, the will file? Well, I've done there some concentric, well, not even concentric, I've done some rings there that demonstrate from bottom to top the importance of the evidence when it comes to probate dispute type claims. And I would suggest that the will file itself is the most important set of papers that allow us to make assessments and judgments on the merit. And if we're doing it, it means the judges are doing it. So a will file is advantageous because it will record conversations with the deceased. We don't get to do that. You've done that. Hopefully notes are in there, or if notes are not in there, then certain inferences will be drawn depending on what side you're on. It will also set in there some explanations as to why gifting or particular structures of wills were taken in a certain way, and it's contemporaneous. So this will file itself contains everything that we should hope to get, and that's why the Lark and Nugas sort of waives that kind of right to access it, because the importance of it is so great. I should say that you are entitled, in fact, you should turn down a request for a Lark and Nugas type response if there's no reasonable case to answer. Unfortunately, the assessment of that is not always easy. We do a lot of that with our referrers coming to us saying, we've had this letter, do we respond? Because the risk is if you do respond and you shouldn't have done, then of course that's a breach of confidentiality and privilege. So we do help at that front. Next one out is contemporaneous documents. So that might be other documents outside of your will file that we can have a look. So things like the land registry documentations, deed of severance might be somewhere there or thereabouts. There might be divorce papers, whatever it is that sheds some light on why the person did what they did and how that fits into the factual matrix and the legal arguments that are being constructed. You're then out to lay witness evidence, which is always a little bit suspect because before you start, it's at least 8 years worth of memory time that you're having to sort of tread on the eggshells of. And some are good, some are bad, some are helpful, some are not, and it's very difficult to assess. But what you are doing is relying on somebody's recollection. Key witnesses very often are not very partisan because they've got a view as to what they want to happen. So they will be challenged on that basis, and true independent witnesses on the grassy knoll type of thing aren't around in most cases. And then you're out to expert evidence, which is even less helpful in my view. It's good and it's bad in the sense that it will give you an expert's view on capacity, for example, but that view can only ever be based on the will file, the medical notes, the lay witness evidence, and then make a call based on their expertise. It's only ever a call. So you sit there thinking, well, okay, if they're right with all those facts, then that's their conclusion. I've seen plenty of cases go either way on expert evidence. Again, just because you've got an expert saying definitely not got capacity, don't think that that will outstrip a lawyer who's given a lay witness statement that says, I was there at the time and this is what they did. Very often they'll find in favour of the most contemporaneous witness evidence, even when you've got some expert evidence that's 10 years after the event. So hopefully to give you some idea of what's important on the will file. Again, we can do training sessions on what do I do with one will file? How do I work it? How do I minimize the impacts of Lark versus Nougat statements? What do I do if I get that kind of request? Not much more to go because I'm conscious of time. I've got 20 minutes. So in these 20 minutes, I'm going to talk a little bit more about red flag warnings for advisors. So you've got people coming in to see you asking for advice. You are dealing with their finances. I always think accountants are in a very kind of privileged position really with families, is that particularly if you're running families in the plural. So if you're looking after a family business, for example, you're going to deal with and speak to different generations of individuals within both the family and the business. Succession planning, those type of things is conversations that you need to have in life. And I'm sure you work hard to do that. Bear in mind that particular set of juxtapositions when I run through the red flags is that these are one by one. If any of these exist, then you are on notice that you need to be a little bit careful about how you draft the will, how you draft the succession planning, because there's potential for a claim further down the line. So going from sort of down the left-hand side first, blended family we talked about at the beginning. So if there exists a blended family, particularly where the children of both sides are not the same age, so at the risk of damning my gender, if you've got sort of a male, it's a second marriage and marries somebody that's far younger than with younger children, and you've got all the other way around, it doesn't really matter. The fact is that you've got this kind of disconnect in age, which in practical terms has an impact. And it has an impact because when somebody's talking about succession, passing on, inheritance, those type of things, is that it's not an even discussion, and you've kind of got a crystal ball gaze and second guess. So blended families, I would say, are probably 2/3 of the cases we deal with. And at any moment in time, we're running 400 or 500 cases across the team. But I would say at least 70% of them have a blended family of sorts in there. That touches onto the family-owned business that we talked about. So if you've got a family-owned business and a blended family, particularly important. If you've got a family-owned business, and again, the most common example of that is farming. The thing that you will find is the problem, and I'll quote farmers here, is that farmers are amazed. They have a different view of assets. They don't view themselves as owners invariably. In my experience is it tends to be a custodial thing. I'm a custodian of the land and I pass it on to the next generation that comes along. No one sells land. No one turns down the opportunity of acquiring more land if you can do it. But the family-owned business is a problem because what they tend to do is they don't always make wills. In fact, they rarely do. And this is the same for all family businesses, by the way. But they also then, what they are good at is usually tax saving. They'll come to you and there'll be all kinds of single farm payments if you're or a business relief here, or a contract here, or we'll do a partnership agreement because that will help and we'll shed the tax liability. But all of these things face into succession. So when we get a dispute because there's no will and intestacy kicks in, invariably we're then left having to sort of decipher and see how all these various different types of legal documents and relationships fit together, and then try and work out what that means in terms of, for example, the 1975 Act, who was relying on what. And so again, family-owned businesses, what to do there is that, again, it's a discussion. We get pulled in more and more these days into sort of the earlier stage of discussions with family-owned businesses and saying, this is what we're thinking of doing. Can you stress test this for any claims coming through? I had a situation about 3 months ago where a lady brought in her father and said, look, I need you to explain to him what the impact is of marrying his, I think it was his second or third girlfriend, what that will mean to him, to her, to us. And we'd sit down and then run through various permutations as to how that would play out. And that then informed he was a very bright man, and he realized very quickly that I need to make some kind of protective provision to make this work. Family fallout's already, again, you'll know before anybody. You know if it's a family that are coming in to see you, who talks to who doesn't talk to who's a bit tense, who comes in on their own, who comes in as a group. You're on notice. You're on notice that can these people bring a claim? If they can, then we need to deal with it in life and have that conversation. Children living in property is a big one, actually, because that's happened more and more now with this. There's a new word that's creeping in, it's inheritocracy, is that people are getting lifetime inheritances by allowing youngest child to live in the property for a longer period of time. It tends to be youngest, it can be others who still remain behind. And of course, then the will provides for an equal gifting, as most parents do, but you've got a child living in the property and they've been allowed to live in there for quite some time, no rent. And there's an argument from there again about 1975 about what's reasonable financial provision. Has the deceased parent provided some kind of obligation, or created an obligation to this individual to provide for them to remain, even if it's for 2 years or 3 years, or do you kick them out straight away? You know, these are the things that need to be considered and advised upon and importantly recorded on your will file. Naughty is a tongue-in-cheek sort of, you will see signs of payments out to people that you wouldn't expect these payments to go out to. And what I mean by that, as you've probably gathered if you've not guessed already, is that I've represented first mistress, second mistress. I think the record is about the sixth mistress of a particular individual who just had all these particular relationships going. And whilst the family didn't know, he was providing for all of these people. Very wealthy man. And because we were able to prove and they were able to prove cash coming in, they of course then have a 2-year financial dependency claim in a lot of cases, and it comes as a complete surprise to the rest of the family. In fact, these are the reasons why the Victorians created these notions of secret trusts and half secret trusts that you'll come across. So the notion that a half secret trust is I give £1 million to John for purposes I will have spoken to him about, you know. So £1 million goes to John. John is told you're a trustee. The beneficiary is X number of mistresses or people that I don't want the rest of the family to know about. And then you'd have these sort of secret trusts that then would just simply not mention anything at all. So there are devices that are put in there to try and cover this. What I would say to you is that you're more likely to see them because you'll see the numbers, you'll see the deposits, you'll see the more likely withdrawals going out, is to have that conversation. Really difficult, I know, but damn sight easier than the death. Honestly, I've been in rooms where whole families have been living a lie with another set of family. That one guy who died, his two families were literally 3 miles apart. So he had one family in one house and he lived there Monday to Friday, another family in the other house living there Fridays to Sunday, and neither family knew about it. And that's what they ran on, and very sad when he died, because that's when they discovered who everybody was. What I found astonishing about the case actually is that he had a private registration vehicle driving between the two villages. So quite how he didn't get caught, but it gives you an idea, and you will have more notice than most. So yeah, have that conversation if you can. Divorce settlements, important factor, because divorce settlements, when somebody in a will, if you get divorced, as you probably know, you're ignored for the purposes of the will. So any spouse or ex-spouse that's named in a will, and the will is old, so it predates the divorce, they will be ignored. And if anybody's remarried, of course, it revokes the will anyway. But in terms of divorce settlements, the thing that gets missed is that an ex-spouse is somebody who is a qualifying claimant of the 1975 Act. So as an ex-spouse, you can bring a claim against an ex-spouse's estate if they die before you. And then the question becomes, what is reasonable financial provision? Now, the easy ones to calculate is where there's some kind of spousal maintenance in place, where you can see there is an obligation to pay X amount per month. And if that has not been provided for in the will, or my preference is get them insured to cover it off. But either way, is if it's not done, then they will have the right to bring a 1975 Act claim. But we do get more cases, again, than you'd imagine, where people decide not to formally divorce. Might be religious reasons, it might be age reasons, it might be just didn't get around to doing it. You know, as a spouse, it's not about what's fair on a 75 Act claim. It's well, it is about what's been fair. It's not just about needs and resources. It's about what they could have got on a divorce. There is a divorce cross-check that is taken place, and you'll be surprised at the size of the awards that some sort of separated or estranged spouses are managing to get against the survivor. The one question I would ask you to ask is, if somebody has been divorced and there is a divorce settlement, ask them if there is a divorce settlement. Have you got a settlement that codifies the agreement on cash assets between the two that's been approved by the court? In there should be a clause that simply says it is agreed that neither party will bring a claim against the other on death in accordance with Section 15 of the 1975 Act. That clause needs to be in there. If the family lawyer has not put that in there or discussed it, they, in my view, are negligent in failing to do it, because they've left a potential ticking time bomb for that claim to come about. So I would always ask to see it before you actually advise on assets if there's a second marriage coming forward. Promises being made alludes to the equity. So I'd ask the question, have you promised any money to anybody? And then ask yourself the question, okay, if I promised any money or an asset to somebody, did they rely on it? What has that person receiving the promise done, if anything at all, to actually put themselves in a worse position as a result of that promise being accepted? If the answer is they have, then you've got the makings of some kind of promissory estoppel or equity claim coming through. And then the other thing is if you've got somebody who avoids will discussions, it's just a ticking time bomb. So if you've got an advisor who simply is somebody in your team has got a client that just simply refuses to talk about wills, then just cover yourself by writing to them and explaining that you've advised that you should do it, including property and severance of tenancies. Just put that advice out there so that you can refer to it, so that you don't get, like we see, beneficiaries who say they've lost out because no will was done and we're sure you should have advised them to do it. I don't think the duty of care extends particularly deep in that direction, but for the sake of a letter, and you should be asking them to do it anyway, I don't think there's anything lost. So in terms of overview, that's hopefully given you a flavour of the types of claims we've got, give you a flavour of the types of probate, how they fit together, gives you a flavour of, in terms of red flags at the will writing stage, and you're all registered to do estate administration. So what you will find is there might well be some more significant signs of claims. For example, a caveat that's been lodged. We would always say, please don't try and resolve any dispute yourself at your end. I know the tendency is to try and do it, particularly if you know the family and your desire, you know, you are trained to try and resolve problems. So you will want to do it. All I would say to you is this, is firstly, you won't nobody will thank you for doing it, because you'll get in a situation where very quickly you will be conflicted from acting for anybody involved. Likewise, if you are an estate administrator and you're the one that's carrying out the work, as soon as you start acting in favour of one, or be seen to be acting in favour of one as opposed to all the beneficiaries, you risk being in breach. And as you're probably aware, it is a personal liability that attaches to an executor administrator of the estate. So what we would certainly advocate is making contact with us and asking us the question. We've got this position, and as alluded to before, of the 10 inquiries coming in, 3 will usually turn into some kind of case that we need to get involved with. The others, we can just simply direct you in the right direction. In fact, all the claims coming in, all the inquiries, and they come through, you're seeing there a sort of page of various things, but the IDRN is in the middle. So that's the network. There is a button in there that you can hit to refer any kind of inquiry or question through. There is Will Check, top left is our B2C campaign. The Claim Checker is an embedded widget that many of our referrers just put on their site, and it gives a yes, no, maybe answer to the visiting person's question about, can I do something about an inheritance I didn't receive or didn't receive enough? And that is a really clever little bit of AI that will provide them with a report explaining why it's a yes, why it's a maybe, why it's a no. And then that report pings straight through to us. We're very tech driven, so it comes straight into our HubSpot inquiry system, and it goes into our triage team, who will then pick it up and deal with it. It's meta tagged to your site. So the key thing here is that there is a 10% fee share with anybody who's signed up on a fee share agreement with us. There's no contractual hardship in signing it. We simply say we're not stuck in for a year. We take the view that once you've signed it, you'll want to stay in, and if you don't, then you just give a month's notice and away you finish. There's no price to pay. We just simply say anything that comes to us from you, we will give you 10% of our cash that we're paid in respect to that case. Our average fee is about £13,500 across the board. Some are much higher, some are lower, but it's a 10% obviously payment of that. We've also then got the IDR Protect, which is rolling out next year, which is a sort of smorgasbord of protective bits of tech that you can use and charge out to your clients in the right way. So there's the LARC I talked about. We've got something called the Bank of Mum and Dad, which is a way of assessing, because in death, what happens is that most parents give equally if they can, but of course they don't know when they're going to die. And that means that it's very rare for at the point of death for there actually to be equal gifting, and payments that have been made by parents, either because there's a house deposit or there's a divorce fees or there's a car or there's whatever it is, that payment goes out. On death, the siblings look at each other and they become a bit uncomfortable, shall I say, at the fact that there hasn't been equal gifting and it isn't being taken into account in relation to the estate division. And even good families then start to come to blows about how these payments should be treated. Is it a loan? Is it a gift? In fact, we've identified 19 different potential claims and problems that arise out of a lifetime gift. So what we've done is we're creating and launching next year, at the beginning of the year, a piece of kit that takes somebody through scenarios of if this, then that. If you're giving money to your son or daughter, do you want it ring-fenced in case of divorce or bankruptcy? Goes through these kind of things and then generates two things. One is a memorandum of understanding, which we can then use on death to explain what the deceased wanted to happen. And that gets put with the will file. It also then generates leads back to you, because it will suggest, if you want to do this, we would suggest you look at a trust, speak to your advisor. So we're very keen. We don't do the non-contentious work. That's your job. We charge for a single use of the actual app itself, but we leave you to then keep anything that comes back to you. And again, that fits in with our model that it's your client. What we're doing is the contentious bits. All the rest of the non-contentious bits, we're quite happy to feed back to you for you to do. So the IDRU is the IDR University. We've got an internal learning platform, so we make sure all our lawyers are trained properly and they keep up with their CPD. We do offer webinars, contentious clinics, again, all based in the IDRN, which you please do sign up for. And again, no cost to you when you get your CPD certificate coming through. The IDR claim checker itself is now version 2 is just being released. We're constantly updating and looking at ways of improving stuff. But if you'd like to see some more information on that, again, the IDRN, which is our portal for everything really, it's in there and you'll get some idea of how it works, how it embeds, it's white labelable. It will fix all those kind of problems. So I'm almost bang on time, which is quite unusual for me. There's a lot of ground to cover there, as you probably gather. I think the key messages for me to you are that you do you, in the sense that you look after your clients. You will look at it slightly different. What I would say is use us when you need us, and you will need us. There's no doubt about it. And the beauty about using us is, A, we have an NPS and Google score that is phenomenal. We look after our clients. Our lawyers are not overworked. We have a very clear family flex model that it means that none of our lawyers are dealing with more than 25 cases at a time at full-time rates. So we're on top of them. So we help. We work with you side by side. And we then provide all the added benefits of training, widgets, upselling in a way. And it's not upselling in the sense of have 15 trusts for your 15 kids. It's upselling, saying, do you want to protect your will a bit stronger, a bit better? against claims coming in, and there's a genuine benefit for doing so using LARC or BOMAD, Bank of Mum and Dad, we call BOMAD. There's various things that we can do there for you. So happy to talk about any of those things. With 4 minutes left before lunchtime, Pegs, I can't see any questions in the meeting chat. I'm happy to take some in there. I'm happy to take, if anybody's brave enough to come off mute to talk in front of everybody else about it, or more likely, happy to meet up with any individual organisation or person after today to see what we can work bespoke for you, because that's what it's all about. There is no one rich seam for us of contentious probate work. We are friends with lots and lots of people. As a result, we've learnt a lot about how we can provide our services in a way that actually is easy for you, but also provides a palatable benefit as well. So I am going to wind it up there. I'll give it 30 seconds for anybody to ping anything into the meeting chat. Thanks, Penny, that's very kind. So if anybody wants CPD certificates, as Penny says, I will make sure Lindsay organises that and sends it through to the emails that we've got for you from this call.